Hi there, and welcome to part 5 of my deep dive into the judge's summing up at the end of Miss Letby's original trial. We pick things up with child L. I quote report. The judge says it is alleged Letby tried to kill child L by putting insulin into bags of dextrose. Professor Peter Hindmarsh said the hyperglycemia episode for child L lasted from April 9 to 11 and multiple bags had insulin added. He said a not noticeable amount of insulin, 0.1 ml, would have been added to the 500 ml bag, which would not change the color. He was of the opinion that 2 or 3 bags, depending on how many were hung, had insulin added. He said while sticky insulin would account for some of the hyperglycemia, over time more insulin would have had to have been added via a bag, he said. Letby worked 4 long day shifts from April 6 to 9 and had moved house during that time to Westbourne Road, Chester. End report quote. Working backwards, note first of all the artful association of the necessary time just described as needed for more insulin to be added to bags with reference to Miss Letby working 4 long day shifts, here buried in the reference to a house move having no bearing whatsoever on the case. What was long about those particular day shifts? Aren't all shifts the same length? Note also, and this is important, the slow burn self-deletion built into this particular coded communication to jurors. The signal is parceled up with a piece of information which jurors who are focused on gathering facts to inform their deliberations to come would have had no more interest in than learning what shade of brown the judge likes his toast to be in the mornings. They would therefore have read the signal loud and clear, undistracted by having their consciousness moving on to processing the second piece of information in the sentence. For all of us encountering this record subsequently, however, it is a totally different story. Unlike the jurors, we are not task-driven with our attention laser-focused on meeting that task and screening out all the extraneous stuff. Unlike the jurors, our consciousness, and therefore critical faculty, has no reason to not follow its natural inclination, a limitation being exploited here, of moving directly onto the processing of the second piece of information in the sentence, necessarily therefore not fully processing the significance of that first piece of information in the sentence to that given in the preceding sentence. Our attention is further baited with secondary details likely to trigger associated memories, thereby taking our consciousness away from scrutiny of the first part of the sentence even more completely by triggering a totally new train of thought. Think about this. Is there a city or large town in the UK that does not have a Westbourne Road or Westbourne Grove? When I read Westbourne Road, my mind runs towards the Notting Hill Carnival and also a pub called the Westbourne, which was once the place to be on a Sunday evening. Why do we need the address details in being informed that Miss Letby moved house at this time? He's not talking about the digging up of the back garden for buried bodies or buried handover sheets. He purports to simply be mentioning that she moved house at this time. We then have partial repeat of previous quote. He was of the opinion that 2 or 3 bags, depending on how many were hung, had insulin added. How blatant are you allowed to be in conducting a witch hunt before drawing censure or at least comment? Depending on how many were hung? Basically, It seems the only qualification he is telling the jurors to ask as to whether a given bag of dextrose was poisoned is, was that bag ever connected to the baby? This is a joke. Finally, we have the word would in the sentence. He said a not noticeable amount of insulin, 0.1 ml, would have been added to the 500 ml bag. Surely, in a judge's summing up, the appropriate word here should be the more contingent could. Doesn't use of would in this circumstance take the defendant's guilt as a given? How does this judge get away with that without comment anywhere in the media? In drilling down into what the judge said here, as I'm about to, the first point I have to make is this. I do not like Peter Hindmarsh. I do not judge any professional as a person on the basis of the clear competency issues which he and every other prosecution expert repeatedly demonstrated in this trial. I do, however, judge any adult for moral cowardice when not in immediate danger. That, for me, is the litmus test of a good person. If you fail it, and they all did, you are not and do not aspire to being a good person. I therefore have no regard for Peter Hindmarsh as a person. But did he really say those things with such certitude? The answer is no. As indicated in my inordinately long video on the Child F case, the Tattle Life case report shows Hindmarsh doing the equivalent of a boilerplate clause in a legal contract. One of those whose sole purpose is covering all conceivable routes to a possible outcome in order to evade liability for said outcome in all circumstances. Ludicrously, from an evidential point of view, he offered the jurors a mashup of TPN bag possibilities, including whether the same bag was used throughout or it was changed at noon and the two bags, if two bags, whether both were spiked or one was clean. A review of his Child L evidence, unsurprisingly, shows that he took exactly the same approach. If anything, his evidence in the Child L case is even more equivocal because, apart from a vomit-making, lick-spittle statement made under grooming by the foul Johnson KC, which I will come to, the only definitive statement he actually made to the court was this, I quote report. Child L suffered a hyperglycemic episode which lasted from the morning of April 9, 2016 to the middle of the afternoon of April 11, end report quote. Apart from those two instances, everything he had to say was either qualified or educated conjecture, not even amounting to hypothesis. To give an example, he didn't even fully commit to the explanation for the hyperglycemic episode in question being the result of exogenous insulin, saying only that he was quite certain it was non-natural insulin. If he was certain, he would not have felt the need to qualify the word by putting quite in front of it. In fact, he seemed cravenly to only be finding his voice on the question here during the trial through encouragement from the prosecutor. I quote report. Nick Johnson KC, prosecuting, said, "So somebody gave insulin to Child L." Professor Hindmarsh replied, "Yes, I agree with that statement, and I think we should add that it was not prescribed insulin." End report quote. Having now committed himself to the prosecution's theory of poisoning, all that then happened was that, as in the other insulin case, Child F, he simply used his medical knowledge to give credence to that theory by explaining in the most straightforward way, by explaining the most straightforward way it could have been done. I quote report. Giving evidence on Friday, He considered the most likely method of administration was intravenously into a bag of dextrose, a sugar supplement, which was connected to Child L's drip. Professor Hindmarsh said the volume of insulin required would be quite small and would not be noticeable in the bag or from a routine stock check. He added, once in the bag, it's, in a sense, sealed off from you being able to detect it by smell. He told the court that insulin could potentially have been added to at least 3 dextrose bags if the giving sets were also changed. By giving sets, that's the IV long line. Professor Hindmarsh also raised the possibility that if the giving set remained the same, then insulin could stick to its plastic, come off, and then release into the bag. End report quote. The word considered and the phrase most likely express a tentativeness, if not on the prosecution's theory of poisoning, certainly on the all-important pinning down of a method, something essential to getting a criminal conviction, usually. Get to the judge's summing up, and that tentativeness has been upgraded to the decidedly unequivocal, if not definitive, would. Similarly, there is no necessary connection or relationship between potential and the realization of the potential referred to. To say insulin could potentially have been added to some bags of dextrose is not to commit to the position that insulin was added to those bags. That, however, is the position this judge tells his jurors to take on Hindmarsh's evidence in this regard. Given that the identical methodologies claimed for both insulin babies, it is unfair to Miss Letby that the summing up for the jurors does not include the evidence heard of the fact that it is NHS policy to not use the IV long line for insulin delivery for the reason that it is an ineffective delivery method due to insulin's property of binding to plastic, which makes the amount of insulin actually delivered to the baby unpredictable. Had he included that evidence, they may well have asked themselves why one of the 2 most qualified junior nurses at the unit would choose it as the most effective way to use insulin to do harm. Instead, by giving jurors only the tiniest bit of information about that limitation of the delivery method, Goss, on behalf of the prosecution frankly, actually repurposes what is in reality a basis for a reasonable doubt about insulin poisoning in these circumstances into something to actually support the prosecution case. As usual, jurors are artfully led from the reality of this significant clinical fact, potentially decisive in the case, this time by misdirecting them from the sense of the relationship between insulin and plastic, which is inherent in the phrase binding to plastic. This is achieved by the simple device, the simple expedient of replacing the phrase with one newly minted purely for the purpose of Miss Letby's trial, sticky insulin. The advantage of this is that those medically informed can readily use the new term sticky insulin as a substitute for the usual term because they already know that it refers to the binding to plastic property which interferes with the flow-through rate of the insulin, making it haphazard, whereas for the non-medical, notably the jurors, there is created a new barrier to entry to understanding what exactly is being described because the dropping of the word plastic makes it impossible to form an idea of the sense in which the insulin is sticky. On top of that abuse of language to mystify rather than enlighten, there is Goss's old favourite of disinformation. I quote report. The type of insulin used was fast-acting, the court was told. End report quote. This is just something thrown in by the judge for dramatic effect to make Miss Letby, who he has spent hundreds of words up to this point to leave jurors in no doubt is their poisoner, sound even more committed and intent on harm. You see, the only difference between fast-acting insulin and the regular variety is that the former is more labor-intensive, needing to be topped up every 4 to 6 hours instead of every 12 to 14 hours. The judge next gives jurors the following reassurance about the measurement quality of the results relied upon by the prosecution. I quote report. The blood sample passed all the quality control tests and performance checks at the Royal Liverpool Hospital. The judge tells the jury, in short, there is no evidence to doubt the reliability of the test results. End report quote. This is simply propaganda. The judge is aware of the limitations of the immunoassay and that court standard insulin testing only occurs at Guildford, because in the Child F portion of this trial, he actually mentioned the Royal Liverpool Hospital lab asking for a validation test of their result by that Guildford lab. Nonetheless, his last word on this second insulin case is that measurement of insulin by Royal Liverpool is unproblematic. Moving on to Child L's twin, Child M, he makes much to jurors of a paper towel recovered from Miss Letby's home, which featured notes of a clinical nature as well as being a record of administered medication. He highlights another nurse recognizing her own handwriting on that note and giving information that the expectation was for such notes to be disposed of as confidential waste. He reminds jurors that the prosecution claimed, therefore, that the note was recovered from the confidential waste bin. What he does not remind the jurors is of the collaborative way of working among the neonatal unit nurses at the Countess, which, from what I have gathered through study of the case, means that the only thing which is exclusively the responsibility of the nominal designated nurse is that computerized record of incidents generally completed retrospectively at the end of the shift. James Goss also does not remind his jurors that this paper towel is nothing more than an informal version of the same handover sheets, 257 of which Miss Letby had been found to have taken home in her pockets and subsequently kept due to mild OCD, which she admits suffering the symptoms of without actually naming. By the time the judge gets onto Child N, the haemophiliac baby, the fatigue must have been impairing his judgment. I quote report. The prosecution say Letby was messaging a colleague constantly from 8 p.m. while feeding a baby in a nursery, which was a two-handed job. End report quote. How petty, trivial and vindictive can you get? The woman is already on trial for 7 murders and 15 attempted murders. What is to be gained from citing what amounts to being no more than a PDR developmental issue, even if proved, which it hasn't been? The Child O, Child P and Child Q cases were summed up over the remainder of July 6th and the morning of the first couple of hours of July 10th. Apart from slight digs, he limited himself to the pseudo-medical evidence. So that wraps up my my deep dive into his summing up. Feel free to share your thoughts and any information you think might be of interest to myself or any viewers in the comments section. As usual, thank you for watching, thank you for your time, and all the best.